Hey everyone, it's Friday. Is it Friday? Yes, it is. March 2nd, 2012. I'm going to try to tie together some concepts from the last few weeks, hopefully onto one simple piece of paper um, that would be a plea of the Crown to use for foreclosure. And so a lot of things, at least to me, in my mind, have come to light over the last month or so. And now, how do we put it in action for the common man? Well, let's start with some basics. Okay, so uh, bear with me for a minute. This is the Magna Carta, Chapter 11. Uh, Lord Coke's interpretation. Again, he's a book of authority. So what you think of the Magna Carta doesn't matter to me. What I care about is what does Lord Coke think about it? Because they say his is one of the books of authority. And so he was talking about the Court of Common Pleas. The Common Pleas shall not follow our court, but shall be holden in some certain place. So back in the day, the courts used to follow the king, and the king wasn't always in the castle. He was wherever. Well, if you were a subject one place, how did you keep up with where the king was to go to court? He said, okay, well, we'll put the court of common pleas in a certain place. It won't follow the king. Before the statute, common pleas might have been holden in the king's bench. So because a king's bench follows a king, then that's where they could have been held. Common pleas could have been held in the king's bench. And all original writs returnable into the same bench. So if an original writ was written out, all writs would come back to the king's bench. And because it was holden before the king and filed the king's court and removable at the king's will, the returns were wherever we have been, whereupon many discontinuances ensued and great troubles of jurors, charges of parties, delay charges of parties, and delay of justice for the causes the statutes was made. So basically, if you could get your case before the king and yours was the lawful answer, you would get the remedy, no matter what the charge was brought against you. And in a system that must have controversy to survive, that wouldn't be a good thing. And if you don't know anything about their system, it survives on controversy. The only way it survives is for a brother to charge a brother and take him to court. That's one of the things we have to stop doing. But here's the good stuff. So, anyways, what they did then is here it is understood a division of pleas. So when they decided to buy the Magna Carta to leave the Court of Common Pleas in one place, they split some duties out of the King's Bench. It used to be in the King's Bench. So now the King's Bench had a certain kind of pleas. They were called pleas of the Crown. And there are other ones called common pleas. Well, the pleas of the Crown are otherwise and amply called for criminal and mortal matters. Right? So a plea of the Crown, pleas of the Crown, is for a criminal or a mortal action. And then this other one, this placida communa, was called a civilia. So, um, so the coronate, I believe that's the one we want here. Yeah, are divided into high treason, misprision of treason, petite treason, felony, and to their accessories, so called because they are against the dignity of the crown. For these, the Court of Common Pleas cannot hold plea because they are held by common persons. So the Court of Common Pleas cannot hold this plea because they're held by common persons. Right? Well, and it said mortal right here. Well, mortal, subject to death, destined to die. Man is mortal. So a plea of the crown is used by a man. Don't argue with it. Start using it. Um, okay, so that's enough on that one. That's really all I had in that. I want to show you something real quick. All this stuff is on other videos I did, but they're kind of long, I know, and there's lots of information, and I'm just trying to break it down to a few really pertinent facts. So there's a thing called a plaint. In English practice, a private memorial tendered in open court to the judge, wherein the party injured sets forth his cause of action. A proceeding in inferior courts by which an action is commenced without original writ. So, we got two different definitions, right? A plaint is a private memorial tendered in open court to the judge wherein the party injured sets forth his cause of action. Well, that can be you. because you would be the plaintiff. So there's two different kinds of plaintiffs. The other plaintiff, though, is proceeding in an inferior court in which the action is commenced without original writ. Well, an inferior court means there's a superior court that you can appeal it to, which is the King's Bench. So I'm going to send this along. I'm not really going to read this right now, but this is from the Columbia Law Review. It's only 4 pages long. And it has to do with equitable mortgage by deposit of title deeds. So one of the great things we've learned so far is that a deed is a deed is a deed. So a warranty deed or a grant deed is a deed. But a deed of trust is also a deed. It's a deed for something else. They're not the same. They're for different things. The warranty deed, the grant deed, land patent, those things are for the real estate, the ground. But the deed of trust is a deed for another estate. Your all capital letter name landed estate, which was carved from the larger estate at your birth. Drop of blood, whatever they did to breathe life into a piece of paper to create your Ponderosa, has a title deed also. So, but a deed of trust is for them to charge your landed estate. And what you put up on that deed of trust for collateral is the right of sale of the property, the real estate. So the deed of trust isn't for the real estate. The real estate's just the collateral for the deed of trust. The deed of trust is its own deed that has its own obligation. Now, it could be they lent you $10, right? But whatever they did, it has to be less than $20, because if it was $21 or more, you would have to have a jury of 24 peers in a court of law. But you're going into a special proceeding for this, and just by definition, a special proceeding isn't a general proceeding, because a general proceeding follows due course of law. Special proceeding doesn't. It's set up to say the law is not in dispute, just the facts. And if that's what you want to believe and go with, well, then the law has already been decided. They put a claim in, and you haven't rebutted it. So this just talks about a little bit about these, but let's get on to why we're here. So this is my idea of a plea of the Crown. And it looks like I should probably start putting an S here. Pleas of the Crown. And how I would do it if I had a foreclosure and I wanted to get the title deed that's been deposited by the mere act of the title deed to the deed of trust being deposited, gave the lender an equitable mortgage over your estate. Just because the paper's sitting in a drawer and you agreed to it verbally. So maybe sometime at the closing table they said, well, okay, we'll deposit this for you. Thinking in your mind they're talking about the check. Okay, fine, right? Well, they deposited lots of things, one of them being the title deed. And there's many things that can be deposited. Go look at the definition of deposit. A deed is one of them. And as long as it's deposited, the person who has it on deposit or has put it on deposit has an equitable mortgage over the security. And the security is these payments that you're making into the escrow account. So in my opinion, this escrow account that is attached to your deed of trust has lots of things in it. They've had to keep track of everything that it's created since it's been gone. These are on the other things I've done earlier this week. it looks like that the lender then takes it, and so we've given them the deed of trust. They have the original copy, the title deed copy. They've not recorded it. They just deposited it, and it's been filed someplace. And they take a copy of the filed thing, and they put it in the public record. But it's not the deed of trust. The deed of trust, that true deed of trust, is on deposit, and it's on deposit at the title company, according to California. And I'm going to say wherever the escrow is. So they're the ones who are the depositary. And we need to find out from them what are the conditions to have it taken out of deposit and given back to us. But if you're in court right now, so I mean, if you're not in foreclosure, you could just start making those phone calls, and we could figure it out that way. But if you had to go to court today because you're losing your house, well, it's time for a pleas of the crown. So pleas of the crown, they only go one place, the King's Bench, by definition. By definition from Blackstone, he says the pleas of the crown are a complaint on which the king is a plaintiff. I like it already. So I would put county of, and then put your county. So here would be county of Kent, no state. And I'm basing that on when I look at documents I've gotten from my birth records. It'll say, I, Stephen Toth, clerk of the county of Bay and the circuit court thereof. It never said Bay, Michigan. It just said Bay. So it's just a county. A county is the largest body politic. The plaintiff would be my first and middle, right? Robert Allen. And I'm going to call myself a son of God. If you don't want to put it on there, don't. I'm doing a chosen action to terminate the unlawful foreclosure by special proceeding, return of title deeds, escrows, costs, and damages. Special proceeding number. Well, whatever your case number is, and whatever other information you think you need to put down to identify it, put it on there. And I like the word oyas. Oyas, oyas, oyas. I should have looked that up on Bouvier's, but it's used before to open a court of law. It sounds a lot like Oz. Say Oz 3 times. Okay, so this is how, it's a complaint, right? It's not a court case, so it's a letter, basically, and everything has to do with this. What's the title? You gave it a title, pleas of the crown. It only goes one place. It's a complaint upon which the king is a plaintiff. And it's going to the King's Bench. So I, Robert Allen, son of God, here is one of his people. Or I am Robert Allen, son of God, here is one of his people. The name Robert Allen is a gift from the Creator, and you will address me by no other. I claim superior rights, title, and interest to my earthen vessel, landed estate named Robert Allen Rutluski, the all-capital entity, and its real property and interest. I avoid any deed that I was grantor of as an infant, by which some stranger claims to have an interest in my lands or estates. I am no man's bondservant. I am a sovereign power, Lord paramount of my nation state. You are the subordinate, and the Father is our witness. I love to bring God into the table, man. Bring Dad in whenever you can. Make everybody stand with their conscience before the Creator, accept their damn oath, bind them to it, and tell them they have a fiduciary duty, and God is now witness to their deeds. Any registration of my earthen vessel, landed estate, its real property and interest, is to be investigated by sergeant at law, master at the bench. Apparently they're called masters at the bench now, for misprison. I am not across the sea, infant, incompetent, or other malady. I am the proper owner of my lands and estates, and you will acknowledge it so or be in violation of your oath, vow, or promise. I accept and acknowledge the dominion granted me by the Father over my lands and estates and the enjoyment of his creations as a son of God and rightful heir, living under his law. This special proceeding is an attempt by misprison to unlawfully foreclose on my estate, and is to immediately be investigated by the Court of Inquiry for criminal misprison of some and misprison of treason by officers and their subordinates. The plaintiff of this special proceeding has not appeared in proper person, nor submitted any sealed evidence for his claim. I demand his affidavit under penalty of perjury for the action he has brought before the court to substantiate his claim, or he face criminal investigation by the King's Attorney General And if misprision were found, that it be prosecuted. Let them be known by their deeds. I demand the depositary for the deed of trust, mortgage, whatever you need to put there, bring forth the title deed deposited and a verified statement of account for the principal and interest owed for the money lent, and a certified copy of any agreement specifying the conditions for the deposit being released to the rightful owner be placed into evidence under seal. As this case is cognizable in common law and currently proceeding without a jury of 24 peers, it can lawfully not have a value exceeding $20. I claim all rights, title, and interest in the real property. Robert Allen Rytlewski. That's your Ponderosa, man. That's your landed estate. And it's personal property. That's the escrow account you have all over. I wish to remove from deposit any title deed it is associated with. It's returned to me, and the escrow of my personal property be made available for this king's use, and my name enrolled in the book of life. Any specific evidence you may require to substantiate my claim is available as public record, and you are duty bound to investigate. I accept the oaths of all officers, bind them to it, and remind them they have a fiduciary duty to me. Your acceptance of a copyhold estate has bound your soul to eternal damnation if you should ever break God's law, and he is now witness to your acts and deeds. You of the Privy Council are now charged with protecting this king from belligerents and from their attacks on his lands and estates. The king is never legally liable, and any controversy this king is involved in is due to the dereliction of duty of an officer or his subordinate to be investigated by a court of inquiry. The controversy immediately extinguished. Ecclesiastical authorities. I am a son of God, and your statute laws are not binding on me. Any attempt by your courts, officers, clerics, officials, or their subordinates to bind me to your laws marks you as a heretic, and I demand the Vicar General investigate your heresy and prosecute your sin. This solemn asseveration, the Father as our witness. This should say this my solemn asseveration with God the Father as our witness. And then I just signed my name because as long as it says seal behind it, you've done it under seal. So you can use whatever you want as a seal. Everything in common law must be sealed. Nothing needs to be signed. Must be sealed. Must be sealed. And a man's seal is whatever he decides it is. So if you write your name, I would write Robert Allen Rytlewski, just like I've signed it my whole life, and put the word seal behind it. Now it's a seal. Imagine that. There's one seal. Okay. And I've called myself as a witness. That's what an asseveration is. I've put my conscience before the Creator. I don't have a problem with it. And a man's conscience is always before the Creator. That's why he doesn't have to take an oath. It's just your solemn asseveration with God as your witness. So the blue part here, this is where you put in whatever the certificate of acknowledgement statement is you're going to use for where you are. And there's plenty of ones out there. The documents I've already posted have the wording I used on it for Michigan. So, that's what I would use again. But, call yourself a living man. Call yourself a freaking king. Not a person. You're not a fucking executor. Excuse my French. These are executory devices. The next word after executor, executory. You cannot be a sovereign and an executor. It just doesn't make sense. A freaking sovereign's a king, period, and everybody else works for him. So then get a certificate of authority. Now here in Michigan, it's really easy, right? So I do an acknowledgement certificate with a notary who's going to put a seal on it. Basically, they're witnessing that I have said, I have written this of my free will, act, and deed. No coercion for me to do so. Okay, so now I have hers. Now, if I go down and I get a certificate of authority for the notary, that's saying that a second witness has verified that the notary at that date was able to do what she did. And so it's just attesting to the seal of the notary. But it's a third witness because it's a third seal. And in Michigan, that seal is under the court of record of the county. And an order under the seal of a court of record of the county is binding in all courts around the world. The Supreme Court can't turn it over. They've said so. All right. So if they can't overturn a ruling from a court of record under the seal of a court of record, then who's more frickin' superior, the Supreme Court of the United States or the county court that put the court of record seal on it? It's not that hard to figure out, man. It's the court of record. That's where the power is. And okay, so when you get it, so I know some people have a problem with notaries. They say you got to go to the state to get it. All right, well then don't use them. Go to the frickin' county. Any competent officer can do a witness on a certificate of acknowledgement. It does not need to be a notary. They're just one of many competent officers. You could go to your township hall. Somebody there will be a notary. You could go to the county clerk. Any of them, they can do it, and then either get it from them because they better have those on file there, or get a certified copy of their oath. Now, you probably could do the same thing just using 3 other people as witnesses. The only reason I advocate this is when you get that second seal, it's under the seal of the court of record, and therefore it's due form of law, guaranteed full faith and credit by the Constitution. The court system you're putting this into has already acknowledged everything you've said to be true. It's got their seal on it. That's the reason for putting up with the shit about getting the certificate of acknowledgement done and finding a certificate of authority. And you shouldn't have to go to the Secretary of State. So I'm going to say that a certified copy of somebody's oath, right, is the same as a certificate of authority because it's showing that on that day that person was under oath. Here's a certified copy. And I'm going to make him rebut that it is. So anyways, this is all I would use. I would use this right here. Fill in the blanks with your information. Now, where do you take it? Well, the first thing you're going to do is get it entered into your court case. So I would go enter it into your court case. People tell me they don't have court cases. Well, if you have any kind of case going, there's a case going. There has to be. And it has a number to it. So you need to track back the number to find out where it goes to. But at the end of the day, take it to the county clerk or the clerk of the courts. I would take it to that. I guess I'd take it to the clerk of the court. Start there. Because this is going to be an original and you're going to keep the original. You want them to have certified copies. You're going to have the original. See, right now, even in your property file, there could be a copy of the deed of trust, right? But it's a copy that it's been filed, not that it's been recorded. It has not been recorded yet. It's still on deposit with a depository, which is a trust company. Who's holding the damn trust, right? Who's got the mortgage? And when it was deposited with them from the lender to them, it came with the instructions that are necessary for the proper owner to claim it. So they have them. They have to have them. And if they're not going to give them to you on the phone, then then you would take something like this, change it because you don't really have a case number yet. If you're, let's say you're not in foreclosure, you don't have a case yet, right? Well, you don't have a special proceeding number. But you still want to have the court make the depository give you the information. So you would still submit it as a pleas of the Crown. And because it's a criminal complaint, you would take that to the prosecutor. So I really think the place that these need to be taken to is the prosecutor, the county prosecutor. It's a complaint on which the king's the plaintiff. And technically, it would be to the king's attorney general, who may not be the elected prosecutor. I'm kind of amazed to see these guys that go to your prosecutor's section of your county, and you'll see a guy who's like the chief assistant, right? Chief assistant prosecutor. I bet you he's not elected; that he's appointed, and because he's a chief, he's a lord, he's a landlord. He's actually the king's attorney general. Because these officers we see get elected in and out, they're from the Constitution, but this other system is living under English law. Right? So their sheriff gets elected every year, and the king does have an attorney general. And he doesn't get elected. He's the king's attorney general, so he would just be appointed. Anyways, we're finding out more every day as we go through this stuff, and I don't have one of these to do it with, so I'm not going to. But I know a lot of people may have something tomorrow they need to do this with, and I'm going to do one next on indictments, which are really no different. They're another special proceeding. They're just done differently, called different paper. But you're going to find that everything's a deed of trust on which there's an equitable mortgage because the deed of trust has been deposited someplace. I think in a foreclosure, the attorney who's bringing the charge against you actually has the has the instructions. He has whatever it takes. He just hasn't given it to you for you to discharge the matter. And it could be as easy as writing a check for $10 plus interest. Or hand them a $20 bill, Federal Reserve note, and say, well, I consider this a dual use bill. I consider the debt paid. And do it in open court. However, we should be able to get a copy of the damn agreement that says exactly what we need to do to claim it. We lost our copy. I need a copy of it. Well, the people that have it are the people who are holding on deposit the mortgage, because they're the ones that have to make sure you follow it. So they have a copy, and they have the mortgage. And it's the trust company. And it's tied to the escrow account. And in that escrow account is all these payments you've made. And they've had to keep track of all the income it's produced, and it's all yours. You just need to go claim the deed of the title deed to the deed of trust. And when you do that, they will no longer have any right of sale, because now you'll have the original deed in your hand. It's yours. That's the deed we need to get. Because on that deed of trust, you've put up the land, the warranty deed basically, as a security. So it doesn't matter if you're the owner or not, as long as they have an equitable mortgage over the deed of trust. They set it up that way on purpose, obviously. All right, think about it. So you need to go get the title deed to the deed of trust. Okay, I beat that horse in the ground. That's really all I had. I will send this out, and I hope it helps you all.